As case number 113291, Daniel Becker be the Bar Plan Mutual Insurance Company.
Mr. Chief Justice.
Counsel, why don't we wait about 15 seconds and let the audience filter out? I don't want your argument interrupted.
Thank you.
Counsel, you may proceed. Thank you.
Thank you. Mr. Chief Justice, may it please the court, Keenan Wall appears on behalf of the appellant Daniel Becker, and if the court is so inclined, I'd like to request 5 minutes for rebuttal.
5 minutes is granted.
Thank you. And by way of factual background, at its essence, this is a bad faith insurance dispute, and it arises from an attorney's representation of our client, Mr. Daniel Becker, who hired counsel to assist him in a series of independent commercial secured loan transactions. During the course of that representation, the attorney failed to conduct a UCC search, which would have revealed that the collateral used to secure the notes had already been pledged. That turned out to be a $5 million mistake, which encouraged the attorney to submit a claim to the bar plan under her malpractice coverage. Eventually, our client sued the bar plan, and the bar plan assumed a defense. And importantly, in our case, the district court made a finding that at the time it assumed the defense of the attorney in that malpractice case, the bar plan had knowledge of potential non-coverage defenses, yet assumed that defense without a reservation of rights. The parties then filed, after some discovery, the parties, excuse me, the parties, the district court found that the bar plan, as I said, undertook that defense with knowledge of coverage defenses and did not reserve its rights. But after developing the issues through discovery, ultimately the bar plan denied coverage, and the attorney that was accused of malpractice ultimately settled the claim and assigned her rights to Mr. Becker. And that's where we stood today in the bad faith claim. And the parties in the bad faith action filed cross motions for summary judgment, which were granted contrary to the interest of Mr. Becker. And at the Court of Appeals, that decision was affirmed, which led to our petition for review and why we're here today.
Just to clarify, you've said bad faith a couple of times. You're relying on an estoppel theory.
That is correct.
And do we have, I don't see where bad faith has anything to do with estoppel. If they undertook the defense, your client relied on that undertaking and was prejudiced, then it matters not whether that undertaking of the defense was in good faith or bad faith or whatever, does it?
Well, I think you're right. I think there's a viable remedy there, just as you've described it. But when you take into account the entire context of the denial,
bad faith comes into play if you want to get excess liability. I understand that, but
that's
I
correct.
understood your first line of appeal was that it was a failure to effectively
reserve the rights under the policy. That is correct. That is our key argument.
And while we're talking about that and your causes of action, have you preserved, because as I read the policy, once they undertake, you've brought it in a estoppel frame.
Yes.
But the policy itself says once they undertake, they have to continue until one or two things happen: the exhaustion of the limits of liability, or a court of competent jurisdiction determining that the policy does not cover.
That's correct.
And neither one of those things happened here. But I don't see that. Maybe you've preserved that argument. Can we even get to it?
I believe that argument was raised. It was not front and center on page 2 and 3 of the Court of Appeals briefing, as well as in the reply brief, I believe around the same page numbers. And later on in page 38, there's a more detailed explanation in the context of excess judgment and why that theory would support the bad faith theory and how those two could be interrelated. So I believe that we've taken sufficient steps to preserve that issue. Thank you. So we've jumped right into the core of the issue here, and I think our position is that the reservation of rights doctrine controls the outcome of this case. And I think what's important in understanding that doctrine and distinguishing the authority that's been cited by the bar plan is to understand that the purpose behind that rule is really driven by the inherent potential for a conflict of interest at the time an insurance company takes over the defense of the insured. That creates this inherent potential ethical dilemma because you have the insurance company that on the one hand has this duty of loyalty to the insured, which is the policyholder in this instance, yet at the same time maintains an interest in pursuing any coverage defenses and potentially severing representation in a relationship altogether. So those two competing interests really create this ethical dilemma. And the court for nearly 70 years has addressed that dilemma through the reservation of rights doctrine. The concept is very simple but very effective in that it stands for the proposition that at the time an insurance company takes over the defense, if it knows or should have known of potential coverage defenses, it was obligated to notify the policyholder and reserve its rights at that time. The corollary of that proposition is equally well established that if the insurance company fails to do so, that they foreclose their coverage defenses. And that's an intentional consequence, and it's calculated and aimed to give the insurance company a mechanism to preserve its defenses under the policy, while at the same time protecting the policyholder who is really induced into that relationship through the offer of a defense.
So did you move for summary judgment on that point?
Yes, I believe we moved for partial summary judgment.
Okay.
Yes, and the bar plan moved for summary judgment as well. And
Do you have to show prejudice? I think we have some case law indicating that if an insurer takes on the defense and has knowledge of the potential, that its prejudice is presumed.
that's correct. That's correct.
But estoppel requires a reliance and a prejudice, right? And what would be the prejudice here?
Well, the prejudice would be accepting an offer of a defense without being informed of the conflict of interest, losing the opportunity to pursue independent counsel or making an informed judgment as to whether or not, as a policyholder, you're willing to waive that conflict of interest. And Justice Johnson, I think you're right. My reading of the case law from the Supreme Court of Kansas is that prejudice is presumed in that context. However, in a slightly different version of facts, were Mr. Becker to have engaged his own counsel and just received reimbursement from the insurance company, there is a line of authority that suggests that in that case they do need to show an actual showing of prejudice, but not when the defense, as here, was provided by the insurance company.
Well, here what I was sort of trying to head you to is we had two offers of settlement here.
Yes, correct.
And as I see, part of the problem with the insurer assuming the defense is that you can have missed opportunities for settlement. The problem here is the proffer was the limits of the policy, so if the policy didn't apply, and maybe that wouldn't have been offered. So that's where I was trying to get you to say whether that was prejudicial to forego the opportunity to settle.
Yes, I think that you've laid out the argument for me. I appreciate that, but I agree that there's that potential. But I think we also see prejudice in the form, really the stereotypical form that this rule is designed to avoid, in that you have an offer of defense without a reservation of rights. The policyholder accepted that unknowing or had no idea of this potential conflict of interest. And so what happens in the interim, the several months that transpire between that defense and the cancellation, is you have insurance defense counsel developing discovery with the policyholder, developing the defenses, filing the answer, and at the same time, as they're reviewing this information, the insurance defense counsel is reporting back to the bar plan that this is a dog of a case. We've got multiple millions of dollars at risk here, and liability is clear. This is a case we need to settle. Armed with that information, the timing of it is when the bar plan receives this feedback and information, the timing is such as that's when they begin to explore the coverage defenses. And that in itself is a form of prejudice in the most stereotypical fashion in this context, in that information shared in this attorney-client relationship could potentially influence the coverage position of the bar plan. And I think that's the core type of conflict of interest that bar plan, that the rule is driven to avoid.
I understand that point, counsel, but actually we have something other than the stereotype here, because the insured is a lawyer. So that lawyer is aware, really, of some of the ins and outs of how these cases work. Wouldn't you agree with me? I mean, they're really not a completely, a lawyer is not completely without knowledge of how this conflict of interest arises and how it's provided for. So the real prejudice arises from the delay and the reservation of rights, not a lack of knowledge that such a thing is possible and how it works.
Yeah, I agree that she maybe stood in different shoes. I think the record evidence suggests that she wasn't familiar with that process as a purely transactional attorney. I understand your point, however, that an attorney oftentimes is charged with a higher level of knowledge. The court hasn't thus far distinguished the rule based on those facts, maybe to account for those circumstances. But I still think you're correct that delay in and of itself is prejudicial. And beyond that, the precedent of this court has made clear that in our context, we don't have to actually demonstrate that prejudice. It is presumed from that lost opportunity to make an informed decision as to whether or not to proceed. And if you're going to minimize that to some extent based on her position as attorney, you still have the continued prejudice in that the reporting back to the bar plan gave them information essentially that may have, or at least the timing can support the claim that influenced their coverage position and ultimately wanting to abandon coverage. And I see that I'm out of time, but I'm willing to answer any additional questions.
So go ahead, Jesse Johnson. It sounds like you're saying the insurance company then made a decision between two bad choices. One is we'll deny coverage now, and we'll take our chances later that we're going to be sued for a wrongful denial of coverage, i.e. bad faith, or we will grant coverage and take what probably is a clear-cut case of attorney malpractice. Is that what you're saying would be two choices that the insurance company had, and they decided to go with something that was less risky than
I'm
providing
not,
the coverage?
Yeah.
Is that where we are?
Thank you, Chief Justice. Almost. I think that that's a fair way to characterize it. I think there was a third option. I think they could have defended this case with the reservation of rights. They could have still offered a defense, fulfilling their duty to defend the policyholder, yet not necessarily having to indemnify them had they properly reserved their right to assert those non-coverage defenses at a later date. And the district court made the finding, and it's supported by the record, that they had that knowledge at the time they assumed the defense. And therefore, based on our court's authority, they understand and bear the consequences of that decision.
Cool.
The attorney, Ms. Seck, had malpractice with the bar plan in the 2011-2012 term, October to October, during which the occurrence happened. The occurrence, the Malpractice Act was during that, I'm going to call it the 2011 policy period.
Correct.
And the 2012 policy period was when she made the claim.
Correct.
So she had insurance with the same insurer that was collecting the premiums and providing malpractice in both the occurrence and the claims made periods.
Correct.
It seems to me there is some case law out there when an insurer denies a claim based on notice, that the insurer has to show that they were prejudiced by the notice. But you didn't raise that issue, did you?
I cited in the reply, I think with a CF designation, that notion that in the claims made context even, a failure of adequate notice isn't a definitive policy defense, and implying as such that there should be a demonstration of prejudice. But you're correct, that wasn't the focus of our argument.
And part of the argument is that she should have known in 2011 policy term that there were acts that would give rise to a claim, specifically through the February 6th, 2012 email.
That's correct.
And should have put it on the renewal application for the 2012.
Yes.
And would the company have been within its contractual rights to non-renew then? And
At
my
that
point
juncture,
being, if they
yes.
had
Yes, I believe so.
non-renewed, if
Yes.
they had non-renewed, and then they could have used the definition of a claim,
Yes.
which is a demand for money or services, which arguably hadn't been made yet.
Correct.
There were general, I'm going to have damages, I don't know, but there wasn't a specific demand for money and services. So effectively then, your client could have not had a claim.
That's
Because
correct.
the act happened while she was insured with the bar plan, but there wasn't a claim by contract, and then the claims, and then they non-renewed, and then she wouldn't have been able to get another insurer, because she would have had to disclose that for the other insurer.
Correct.
Okay.
That's correct. Thank you.
Any further questions? Thank you, counsel.
Thank you.
Mr. Chief Justice, members of the court, may it please the court.
Can you address my catch-22 circumstance while it's on the
Yes.
table?
Yes, and I tell you, and if I can even back up just a little bit further, Judge Johnson, one of the things that you had just asked before that question had to do with notice and when notice is given. And the notice cases that deal with prejudice are occurrence policy cases, because you have an occurrence that occurs, but you don't tell the insurance company that you've had this lawsuit or whatever, and the question is, are they prejudiced by your delay in providing notification? In a claims made policy, though, it is not notice per se that is the same notice as in the occurrence policy. It is specifically that both the claim and your notification of the insurance policy or of the insurance company have to be within the policy period. If that does not occur, then there is no coverage. And the reason for that is a claims-made policy allows the insurance carrier to define its risks year to year to year. Different from an occurrence policy. You write a policy and 5 years later a claim comes, you can still be on the hook for that. But then in answer to the second part of that question is, when Ms. Seck fails to provide notification, and let me back up, the acts giving rise to her malpractice actually occurred before the 2011 policy period. It was during the 2011 policy period that Mr. Becker began providing her with notice that she had, in fact, under the language of the policy, that she had committed an act. And that specific language is that she would have to have a basis to believe that she had committed an act or omission. The act or omission occurred well before. He's then providing her with information from which, under the Cahill case, both a subjective standard and an objective standard, she should have known.
It wasn't way before, because Mr. Becker didn't start making loans until 2010.
Right, but I mean, it was before, I didn't say, if I said way, I apologize.
Okay.
What I meant was it was before the policy period began in 2011. Just wanted you to have that timeline there.
And
But
did you insure her during the 2010?
I believe they did, Judge.
Okay.
I believe they did. And the point being that counsel raised, had she advised with respect to this information, had she done what the application requires, what exclusion L requires, but more importantly, what the grant of coverage, Section 2 of the policy, provides, had she provided that information, then a number of things could have happened. She could have been non-renewed. Number two, though, she could have said, I want to pay more premium because of this. And perhaps they would have insured her. But the insurance company was not allowed that option because she did not provide the information. And both the district court.
And so you're saying that it's on your claims made, the vagary of when the actual damages were determined whether you paid for the coverage that you collected the premium for.
It's not the vagary of when the damages are determined. It would be the point in time at which the insured believed that she had committed such an act or
How do you
omission.
get past your definition of claim?
Well, but there was no claim, Judge. And that's what the courts, both the district court and the Court of
Okay.
Appeals found, that there was no.
Let me go back.
Yes, sir.
If she had said the email on February 6, 2012, lead me to believe I may be in trouble here. If Ms. Wood pays off the loans, there's going to be no damages. You
Exactly.
agree with that?
Exactly.
And so there's a potential for a demand for money and services, but there wasn't an actual demand because Mr. Becker continued to try to collect from Ms. Wood, right?
I believe that's true. He
So
could
we
have done
didn't
both.
have a claim for money or services on February 6th.
That is true, Judge.
So if she would have notified the company, and the company says, we don't want any part of that, so we're going to non-renew you. And then on October 1st, 2012, she gets the email the day after expiration or non-renewal. She gets the email and says, okay, I've calculated. Even though there was bankruptcy in August, which let everyone know that this was completely gone south, but there wasn't an actual claim made under the terms of the policy, that she would have had an uninsured claim.
Unless she could have obtained other insurance once she let the bar plan know that she was not, or once they would let her know. that they
And
were
why
not
isn't
going
that the vagaries of when she actually gets the claim, the demand letter?
Because the grant of coverage is not dependent upon a claim being made. And a claim is a demand for money or services. The grant of coverage is dependent upon the insured has no basis to believe that they have committed such an act or omission. Has nothing to do with an actual claim being made. It's, does she have enough information, and then under KHAL, both subjectively and objectively, to make that determination. And one of the things that I think was important, and in fact, Justice Johnson, it was in the last argument where you asked a question that had to do with, is there a difference between what a layperson would know and what an attorney would know? And even in the KHAL analysis, the court applied not only the subjective standard of Ms. Seck, an attorney, but the objective standard of the reasonable attorney, not the reasonable man, the reasonable attorney. And we have a situation here where the issue that is being put forth is one of estoppel. And while we talk about estoppel being that there has to be reliance, in the case of Mutual Life Insurance versus Bernasek, 1984 case, it says, while actual fraud, bad faith, or an attempt to mislead or deceive is not essential to create an equitable estoppel, it is necessary to show both misrepresentation and detrimental reliance. And we tend to gloss over that misrepresentation. Did the bar plan mislead Ms. Seck and cause her to feel like she could rely upon the fact that there was going to be coverage provided to her? That's where it comes down to. And when you look at the record, you'll see that Mr. Coffey, in his affidavit, volume 3, page 53 through 57 of the record, on 9 occasions, he wrote to Ms. Seck. 9 occasions. And on each one of those 9 occasions, he said, I need your claim file. And why is that important? Because the February 6th email, they say, is everything. That the February 6th email tells the bar plan, absolutely, you have coverage defense. But that is not true, and especially when we look at what makes a legal malpractice case. One thing that could have happened is that the damages could have been satisfied. If that occurs under the Canaan versus Barty case, you don't have a malpractice case. So then Ms. Seck would not have been in error by not telling the bar plan about it. Another thing that could happen
Well, did that information also include that Ms. Woods had filed for bankruptcy in August of 2012?
Well, that would be information that would be known to Mr. Becker, but it wouldn't be known to the bar plan until they might look at Ms. Seck's file, which did not come until much later. So, I mean, my position would be we have a certain body of information that comes to the bar plan. They say the February 6th, they say the February 6, 2000 letter sets it off, but following that letter, there could be, I mean, an attorney's file, some of the files in my office take up an entire room, and the bar plan says, we need your entire file. Why? Because there may be an email that came 3 days later that said, you know what, I am so sorry, Sheila. I misinterpreted this. I see that I was wrong. So that she would say, I didn't do an omission, or I didn't commit an act. Another thing that can happen is this. An email can be in a plaintiff's submission that was never received by Ms. Seck. Never received. Perhaps it got hit under junk file, perhaps it went somewhere else, but until you see the insured's file...
There are a lot of could-have-bees,
absolutely there are.
The district court made specific reference to that, saying the bar plan cannot argue both that the February 6, 2012 letter should have put SEC on notice of a potential claim, but should not have put the bar plan on notice of a ground of forfeiture or non-coverage. And so the district court's already found that that should have put you on notice to give a reservation of rights, because the reservation of rights doesn't mean you're declining coverage. That means you're covering yourself, that your defense will not be an estoppel. And why, if you can just bail out any time that you're defending, if you determine that there's no coverage, what is the whole point of having a reservation of rights? Why do we require, going back to 1948, the Sedker case says that you have to reserve your rights if you're an insurance company to avoid an estoppel to make a coverage claim. What's the whole point of that if you could just bail anytime there's no coverage?
And Judge, I agree this Nedker case says exactly that. There was no reservation of rights letter there. There was one here. That is a distinction. The distinction here, the issue here is one strictly of timing. And that is what we have. They're asking you to give a bright line rule that you must reserve your rights before you hire counsel. And so what we have is the competing interests of the possibility of coverage that requires the retention of counsel and the duty to defend. And the bar plan followed that and met its obligation in that respect. But because it is a legal malpractice case involving more than one transaction, this is not a car wreck. Mr. Coffey specifically says, so that there would not be an estoppel, there would not be prejudice, there would not be detrimental reliance. He says, once a complaint has been filed, I will go ahead and appoint you defense counsel under the policy, pending a coverage review of the complaint in your documents. Let me know what is in the package and we will go from there. And then when he hired defense counsel, he specifically tells her, please remember that I need a copy of your legal file ASAP, as I will not have, or as I still have not been able to complete my coverage review. It is not a situation where the bar plan is leading her down a path. They're dealing with the situation that especially a legal malpractice carrier is dealing with. That is, you have to look at the facts.
It sounds, counsel, you just said you have to look at the facts.
Yes,
It sounds
sir.
like you're making a factual argument as to whether or not there was actually a reservation of rights.
No, there was a reservation of rights letter, Judge. It
Well,
went out on March 11th. I'm sorry.
As to the specific timing of it.
Yes.
So that goes to my question. If there's a question of fact here, why wouldn't this eventually be determined by a fact finder?
Because there was no question of fact. There were 250 uncontroverted facts that Judge Draghi had before him, and there was no question of fact with respect to what I am asserting.
Your argument is then that it's an undisputed fact that the bar plan reserved its rights when it undertook to provide a defense.
My argument is this, Judge. It is undisputed that the reservation, the detailed reservation, that which is required in order to provide the insured with applicable notice, that went out on March 11, 2013.
Which was after the provision of the defense, substantially after.
January 18, 2013 is when counsel was retained. But when we look at an estoppel argument, Judge, we are looking at this situation of, was the insured informed?
Right, and I guess that's my question. It sounded to me like you're arguing that the insured was on notice at the very earliest stage that that the bar plan was reserving its rights. And that's what I'm suggesting, sounds to me like, is a factual dispute.
It is not a factual dispute. All these facts that I've asserted, the letters that were sent and the Ms. Sec received them, those were all undisputed.
What about Mr. Coffey?
What's the date on Coffey's letter that you quoted?
Judge, I'm so sorry. He sent 9 letters, and I'm sorry I don't have the date. But
In essence, if I can maybe summarize and get to the heart of this, it does sound like, there is no dispute about which letters went on which dates,
That is
whether
true.
they arrived, all of those things that can arise are not an issue here.
they are not, Judge.
But what is an issue is whether what the bar plan did was adequate to kind of quasi-reserve its rights until it actually reserved its rights. Whether that time period was too long, the time period between the assumption of the defense and the actual sending of the letter that officially reserved the bar plan's rights. Isn't that really what's at issue here?
Judge, I believe that is what is
You
the
said it was
issue.
all timing, and so
and-
that's what we're talking about. So it's all about timing, and if it's all about timing, what is the nature of that question? between that letter from Mr. Coffey that you read from and the time of the actual official reservation of rights, what is the nature of that question? Is it a question of law, whether that time was reasonable or not, or is it a question of fact? I mean, that would be helpful to us to have your thoughts on that question.
And what I would tell you is this, and I know this court has de novo review, just like the Court of Appeals did. Judge Johnson, you were referencing the decision by Judge Draghi where he said the bar plan was in fact on notice. So the Court of Appeals took a different tact on that. They basically took a tact that there was no estoppel. You couldn't use estoppel to create coverage.
Expand coverage.
To expand coverage, yes, Your Honor. But what I'm looking at is it was 23 days from when counsel was appointed until Ms. Seck provided her file. And thereafter, it was 28 days when the reservation rights letter went out. So when it sounds like a long time, that presentation of the file is right in the middle of that.
Okay, so just
And
so we're clear, you're not taking the position that the time period, the timing issue that you said this case is all about, it's about timing, is just that 23 plus 28. It's not from Mr. Coffey's letter till the actual reservation of rights.
Well,
the only time period we should concern ourselves with is the 23 plus 28, right?
I believe that the position that the appellant is taking is that the reservation rights letter came 51 days too late. It should have come before counsel was retained. Okay. That is the timing. I take a position, Judge, that when you're an insurance carrier and you have to look at all the facts, that the timing, as long as you are doing it in a reasonable amount of time, that would meet the requirement.
It was functionally adequate under the law. That's your position.
Yes, it is.
So that brings me to this question. What case law do you direct us to tell us that you're correct on that point?
Well, the case law that I can direct you to is a number of cases that do not specifically address this point. I mean, we can look at the Henry case, the Bogle case, the Snedker case. Each one of those is slightly different. Snedker, there was no reservation of rights letter. Bogle and Henry, the reservation was not specific enough. It was a generic review. We have other cases. I mean, this case and I've got it here somewhere, this court in Bell versus, I think it's Titan. In that case, though, this court does say, relying on Iowa Hardware Mutual Insurance versus Bergen, that, I'll be able to read this and I apologize. But it does say that an insurance company, before undertaking the defense of a person claiming to be an insured under the policy, may by proper notice to such person and without notice to claimants asserting a cause of action against such person, reserve the right to question coverage and assert policy defenses. And that case could be argued to say that it has to be before the attorney is retained. But that case does not define a way that an insurance carrier can provide, quote, proper notice. And so is proper notice the same as a detailed reservation of rights case when we're dealing with an estoppel issue? And I would submit that proper notice is telling the insured time and time and time again, we need your file so that we can do this coverage review. And when you do that, you have given proper notice, and that notice was given before defense counsel was retained. And once defense counsel was retained, the file was received, then a detailed reservation was sent out based upon not only the February 6, 2011 email, the specific reservation rights letter and then the declination letter that came detailed the numerous emails that came before the February 6, 2011. Yes, Your Honor.
No, go ahead and finish.
No, I was just going to say that there were numerous items that were found in the file after it was reviewed that had not been provided previously.
I know you say that the plaintiffs didn't preserve this argument with regard to your contractual duty, but humor me and answer this. The duty to defend in subsection B or B subsection 1 that says the company has the right and duty to defend any claim seeking damages to which this insurance applies. And the damages came from a attorney malpractice. And that is the whole point of this policy. And in fact, you would agree that on September 30th, 2012, if Ms. Seck had submitted the demand letter for Mr. Becker, you would have had coverage and we wouldn't be here.
I agree with that.
And so what we're talking about is a matter of timing. When you're talking timing, this insurance applied to the acts in which she that she committed. And then, if we read that way, a duty to defend, then the subsection 3 says that you will continue that your duty to defend only ends under those two circumstances I mentioned earlier: exhaustion of limits or a court determination
It's true.
that there was no coverage. So how do you get around that you should have known from your own policy that once you entered upon a duty to defend, that you were placing yourself into the circumstance that you would continue until section B3 came into play?
And Your Honor, I appreciate that. Number one, as the court indicated, we do not believe that was preserved. But number two, and I think more importantly and logically, is that that section has to be read as there is coverage, because when Your Honor says that this policy applies and you say it's a point of timing, it's not timing in that instance.
We read policies, construe them against the scrivener, especially an insurer, and it doesn't say seeking damages which are covered. It says to which the insurance applies.
And Your Honor, I mean, if I can answer, when it says to which this insurance applies, and Your Honor makes a point that it is timing. It is not timing in a claims-made policy. I'm sorry, but it is the issue of how coverage becomes in effect.
The whole point of claims made is timing. It's not what happened or when it happened, it's when the claim is made. I mean, the whole thing is timing.
It's when the claim is made and reported. And so, yeah, I guess you could consider it timing, but I consider it that's when there is coverage, when you meet that specific claims-made definition. If you do not meet that claims-made definition, there is no coverage under Section 2. And your analysis stops there because there is no coverage. So then you're saying that the bar plan should now be stopped because it provided a defense under its possible duty to defend, the possibility of coverage, and so then the bar plan should be penalized because it did what it was supposed to do on one hand and then found out there was no coverage under the policy. So I do not believe that specific provision applies when there is no coverage, Judge. And
Counsel, sorry, go
I
ahead.
know I've gone well beyond, Your Honor.
In your experience, have you ever run into a situation where the insurance carrier was notified by the insured, say, I got these legal papers served on me. It says something about I have to file an answer tomorrow. Can you take care of this for me? And the insurance company says, we're going to get a lawyer for you to protect that answer date. And then after that is when the issue of reservation of rights comes up. Has that ever happened in your experience?
It's happened, unfortunately, it's happened to me many times in my own personal experience as well as in the kind of work that I do representing lawyers.
And would we be discussing whether there was some sort of an estoppel for a plaintiff in that situation? And if so, would we be looking at whether it's reasonable time period has passed? I just want to make sure I understand what your test is.
Well, because I guess what I'm, and again, I'll bring it back to what they're saying is there should be a bright line decision. If you hire an attorney and you do not reserve your rights, you're stuck, okay? Then what I would say is that in every case, the court has to look at it differently. And that's why I believe that, in fact, attorney cases are different. because the nature of what has to be examined is different than a car wreck, and you look at a police report. The same thing would come up in a case like that. If the first notice of claim to the insurance carrier is that here's the petition served on me, my answer's due tomorrow, or in my case, I can't tell you how many times it's been, that was served on me 45 days ago. And can you get an answer on file, which then requires me to move out of time and things like that. But the insurance company doesn't even have the facts at that point in time. So I do not believe that there can be a bright line. I believe that it has to be an analysis of what is reasonable under these circumstances, and under these circumstances where, or even under those circumstances, there has to be an element of reason.
What's the reasonableness apply to? Reasonable for the insurer to know facts exist that might lead to a coverage issue? Or do you reasonable to know slam dunk that there's a coverage?
No, there would be, I believe the first one. I do agree it is might lead, Judge.
I think that's what Judge Draghi was saying, that if you're saying that these facts led this attorney to the point where she should have known there was a problem, that the attorneys at the bar plan should have known the same thing, that if she should have reasonably known that, that can create a problem with the notification to the company, which we didn't get. And maybe that was sufficient notice, maybe it wasn't, but it's the red flag. Red flag for her is red flag for you, is what Judge Draghi says, and I'm trying to find out why it was not a red flag for the bar plan.
Well, and Judge, I understand completely that's what Judge Draghi said. I have argued against that, and here's why. Because a red flag for Ms. Seck is that then she has to report it to us. The issue with respect to a reservation of rights letter is whether or not Ms. Seck actually committed the act or omission. And when you get into committing the act or omission, or under exclusion L or under the application, which are all part of the policy, there can be things in her file that, while Judge, that excuse me if you can let me just finish, but there can be things in her file that exculpate her or that change the nature of the claim so that it, or the claim, the what is then a claim, that mean she would not have known because there are no damages. Or he said, my foul, I'm sorry, I made a mistake. Or she didn't get the email. And that is what you have to look at, rather than, our position is, when you're dealing with attorneys, when you're handling specialty lines of insurance, that you should not be willy-nilly sending out reservation of rights letters until you have reviewed the file. It is that important. I see it all the time, that the file contains information that would exculpate an insured in this situation.
But you didn't deny coverage because there was evidence that she was exculpated. The reason you didn't even contest whether the acts occurred, that had nothing to do with nothing with regard to the declination. The declination was based on she got notice, at least by February 6th, that there should have led a reasonable attorney to know there was a claim and didn't let you know.
Right. That is true, Judge.
And
It can go either way.
yeah,
That's the bottom line.
It can.
The additional
And
investigation can go in your insured's favor, or be pro coverage or anti coverage.
And I guess to end up on what I was saying is, but the issue is, we know they did not issue the reservation of the rights. The issue is, though, are they then stopped to deny that later on? That's the issue before the court. And you're stopped if you've misled someone and they've detrimentally relied on it. And in this case, they did not mislead her. They kept saying, we are going to do this, we need your file. And I think that's where it comes down to.
why isn't that a fact question? Why isn't that a fact question, whether she was misled, whether she relied? That requires some credibility determination, some factual findings, and we have a summary judgment here.
Well, both parties filed for summary judgment, and we had uncontroverted facts, and the court determined that there was no factual dispute with respect to what she had been provided. And you know, when I look at it and say a reasonable attorney, I don't think that you would have to say whether or not she could understand complete my coverage review. I believe every attorney should understand what that means, and she was an experienced attorney, and I think when you're dealing with insurance coverage, that is something that she understood. And I don't really believe that is a factual issue. I mean, perhaps if it had been someone who was not schooled in some of the things that we've been schooled in, there might be a different issue, but I don't believe that there is a factual dispute there.
Counsel, I think we've covered your position.
I think you have, Your Honor.
All right.
I appreciate the court's time. Thank you very much. We would ask that the judgment be affirmed.
Thank you. Reserve 5 minutes for rebuttal.
Chief Justice, may it please the court. Just want to pick up on three arguments that were raised by the bar plan, starting with the preservation question on the contract issue, section 2B3. Just for your own reference, on page 2, page 36 of the initial brief filed with the Court of Appeals, and on page 3 of the reply, that issue is raised. My understanding is was also argued before the panel of the Court of Appeals. Notwithstanding that issue,
And then take it the next step. Were preserved for review.
correct, and that having then assumed the defense in this case, they have.
Your argument is that it's also preserved for review?
Oh, yes, correct. Yes, Your Honor.
Yeah, you preserved that in the petition for review.
I'm sorry, that it was preserved below at the Court of Appeals in page 2 of the Court of Appeals brief.
But
And-
we're on review.
Yes, I
We're on a
understand.
petition for review. Even if it was presented there, you have to show that it's legitimately up here.
Absolutely. I understand that argument. And I believe that on the initial petition, I thought that we had raised that contract issue as well. And as well in the reply brief with the citation to the contract claim, particularly the reply citing the provision 2B3 specifically. But more importantly, all of that aside, we still come back to the reservation of rights rule, and there's three arguments that I'd like to address quickly. The first is this notion about the file delay and coming up with some sort of a complete coverage defense and position to articulate in the context of a malpractice claim. And as the court has identified, the district court identified that as a red herring because there's for purposes of congruency and logic, that February email can't trigger a reporting requirement on the part of the policyholder, but not be sufficient to charge them with notice of a coverage defense. In fact, their own expert testified and confirmed that when they received that email in November of 2012, that was sufficient information for them to issue a reservation of rights a letter. That's in volume 4 of the record, page 188 to 89, and 192 to 195. Yet they did not. And 6 weeks later, they assumed the defense without a reservation of rights, which puts us directly into this court's precedent in Bogle, Henry, et al. As to the result. Also,
Counsel, I understood your opponent's argument to be that, in fact, we did reserve our rights prior to retaining counsel.
yes, that's the second argument they advance.
Was that, as a question of fact, determined below during the cross motions for summary judgment?
My recollection was undisputed that no reservation of rights letter was issued until March.
That's a different question, though, than whether
Yes.
the bar plan actually effected a reservation of rights prior to retaining counsel for Ms. Seck.
Yes.
And so that's what I'm asking. Was that fact question presented in the cross motions for summary judgment?
No, not to my recollection. It was not. I don't recall any finding by the district court or any argument to that effect.
So it's not that fact question was undisputed. It's that fact question was unaddressed.
That's correct. That's my recollection of the briefing below.
Counsel, I'd like to return to a point you made before Justice Stiegel's question, and that was the November 29, 2012 date.
Yes.
Coffee receives a packet of information from Becker's attorneys, which includes the February 6, 2012 email.
Correct.
Are you saying that is the...
Yes.
Okay, but well, my point is, at what point should the bar plan have said, here's your letter, we're reserving our rights?
At the point they offered the defense with the knowledge of a potential coverage defense under the policy, in this case, January
25th, 2013. If they had issued a letter to the insured, reservation of rights on January 25th, 2013, you'd be satisfied.
That's correct, if it was an adequate reservation of rights under Bogle.
And do those two events have to coincide, or are you willing to entertain the possibility that counsel could be retained on day one, and on day two, the reservation of rights letter could have been received?
Yeah, absolutely.
And so how far in the future do we say?
I don't think
Too
there's
much.
a bright line rule that you can come up with. What I do think the court has already established is that when you are assuming the defense, taking charge of the defense, armed with that knowledge or charged with the knowledge of a policy defense that you could disclaim coverage down the road, that needs to be disclosed. And whether that's a couple days, weeks,
Let's look at the timeline here.
Yeah, but-
We're all talking, the suit was filed in January
correct.
of 2013, but we have the demand letter November 12th of 2012.
Correct.
And we had the bar plan assigned attorney Charles Coffey, and on November 29th, 2012, he received the packet of information from Becker's attorney that included the February 6, 2012 email. He read that and he told Seck, I don't see any coverage issues initially. After he had read that, but he says, we'll be subject to more thorough analysis.
Right.
And so why isn't that a fact question as to whether that statement should have put her on notice, or whether she could have relied on the fact that he said basically the February 6th email didn't raise the red flag on the...
Yeah, I would think at
Okay.
best it creates a fact question that should not have been taken away from the jury in this case. I believe to the extent anybody argues that communication or the notion that, hey, we're going to help you out here pending more review, as a matter of law, is not an adequate reservation of rights under Bogle and the authority, the precedent of this court. And I see
You
that.
know when that conversation between Coffey and Seck occurred? I've got a record site here, but I don't have the date.
I do not have that citation with me handy, the date of the communication with Seck.
Okay, it's in the record.
I don't in the timeline. I apologize.
Counsel, you've made a reference to this should not have been taken from the jury for determination. Is that correct?
Correct.
Okay. And it sounds like you're saying all these facts should have been presented to the jury for them to determine whether there was an estoppel.
Correct.
Okay. And what date would you be arguing to the jury that the bar plan should have issued the reservation of rights?
We would argue that when they assumed the defense unconditionally, I believe it was January 18th of 2013, having had knowledge for at least 6 weeks prior of a coverage defense.
That was the packet that Coffey received.
Correct.
Okay.
Correct. Coupled with the testimony that, that Mr. Coffey claims counsel actually reviewed that communication, and the expert testimony from the bar plan's own expert saying that that was sufficient to trigger a reservation of rights letter.
That's the earliest date that you would argue to the jury?
Yes, because my understanding, my reading of the case law is that when an insurance company assumes an unconditional defense with knowledge that it has grounds to disclaim the policy or is charged with such knowledge, that's the effective date where a reservation has to be made, or you forfeit your opportunity to raise those defenses and you treat the claim as covered by the policy.
You mentioned you had three things, and the first one was the delay in giving the file. Can you just list the other two without argument?
Yes, the other argument was that this, whether or not this bright line rule instantaneous, whether you can receive an answer and put in a defense, whether there's some room for reasonable delay. We've never taken that.
Well, what's the third one then?
Oh, I'm sorry. Whether or not this commentary was from Mr. Coffey was the functional equivalent of a reservation of rights. We think, based on the uncontroverted facts, including the knowledge of the coverage defense and the waiver of the same, we believe that the matter should be remanded and judgment entered on the partial motion for summary judgment of Mr. Becker. Thank you.
Any further questions? Thank you, counsel. We thank you both for your arguments this morning. Court will take this matter under advisement. This time.